Ààrẹ Babalola. Dele Farotimi will be free if he proves allegations in his book. Does he need to prove anything again? You have already given us evidence now that everything he said in this book is the truth. We don't need any other proof again. If you are not misusing your power as a lawmaker in the country, if you are not corrupted as he said, you will not go and kidnap somebody from Lagos State to your jurisdiction in Ekiti State because you want to exercise your power over him, because you want to show that you are really there. There's no other proof again. There's no other proof for what he has written in his book. You have already given us evidence. You have already given us evidence. What other proof? The founder of Babalola University, Ado-Ekiti Abuad, Ààrẹ Babalola, has said that Dele Farotimi, the human rights activist recently remanded by Ekiti Magistrate Court, will be free if he proves the allegation leveled against him. There's no need to prove anything again. You have already given us evidence by yourself, by showing your power, going to Lagos State to kidnap him to Ekiti State, and denying him bail and doing all sorts of things. There's no other proof again. No. You have already given us more than enough. Because Farotimi had alleged Babalola of corrupting the judiciary in the book titled Nigeria and its Criminal Justice System, and was remanded on Wednesday after he was arrested at his chambers by the Ekiti State Police Command. Addressing journalists on Friday at the Babalola Bar Center, Ado-Ekiti, Owoseni Ajayi, the lead counsel to Babalola, said the defamatory remarks made against him in his book were targeted to injure the hard-earned reputation of the legal icon, which cannot be remedied by any award of damages. The former Justice Commissioner in Ekiti, joined by the duo of State's ex-chairman of NBA, Olasunkami Falade, and Lawrence Fasomi, explained that Farotimi has been inconvenienced with Babalola, who won a land dispute case in 2014, where the human rights activist was neither a party nor a counsel to the case. Babalola had filed a motion for the variation of the judgment of the Supreme Court to correct clerical errors on a certain land portion, which further affected some estates, where Farotimi happened to be a lawyer to one of them. Owoseni emphasized that Farotimi wrote the book not because any injustice was done to him, but because he could not get judgments for his clients in court. The lead counsel wondered why Babalola, who was accused of corrupting the judiciary, would lose cases in court and still be fined over 30 million naira by the same Supreme Court accused of corruption. Anything can happen in this country. That one is not a basis. He added that Farotimi's action is an offence punishable under Section 59 of the Criminal Code Act, which emphasizes the publication of false news with intent to cause fear and alarm in the public. What fear and alarm is it causing? What fear and alarm is not causing any fear and alarm. It's just for us to know that this is the kind of person this person is. What fear and alarm is it causing in the public? People have come with agenda. His words, before I tell you my deductions from all that have happened, allow me to first share what transpired with the events. Suit number SC/146/2005. Major Muritala Gbadamosi Letu and ORS v. His Royal Highness Obatijani Akinloye and ORS 2013-15 NWLR Part 1378. The Ojomo family sold 254 hectares of land at Osapa Etiosa local government, Lagos, to the late Gbadamosi Dele in 1977. The said parcel of land was subsequently acquired by Lagos State government in 1989. The Ojomo family contested the acquisition against Lagos State government in suit number ID/1883/89, wherein the court set aside the acquisition by the Lagos State government. The Ojomo family then instituted a suit at the High Court of Lagos State, claiming that title to the land had reverted to the Ojomo family despite the earlier sale of the land to late Gbadamosi Bamidele Eletu. The Gbadamosi Eletu family lost the case at the High Court and the Court of Appeal before briefing Ààrẹ Affairs Chambers to represent them at the Supreme Court. Judgment was delivered by the Supreme Court on 13/7/2013 in favor of the Eletu family, wherein the Supreme Court held that where a party has fully divested himself of all interest in land, no rights vest in him to deal with the same property by way of further alienation anymore. He is caused by the maxim, nemo that quod non habet, that is, it cannot give that which it no longer has. In the instant case, it was unfortunate that the respondents claimed title to the whole of their family land compulsorily acquired by the Lagos State government, including the portions earlier sold to the father of the appellant, and in which they were in effective possession. The claim so made without disclosing the truth and excluding the said portion, so sold was clearly made in bad faith and smacked of insincerity. It was very unconscionable and consequently against the principle of equity of good conscience. By this judgment, the Supreme Court recognized the sale of land to the Badamasi Eleto family. You will recall the 254 hectares were sold to the Badamasi Eleto family. However, instead of 254 hectares, Honorable Justice Kumai Bayang, aka AHS JSC, who wrote the lead judgment, recorded 10 hectares in error. A judge making error. Okay, now. Upon the delivery of the judgment, the Badamasi Eleto family surreptitiously employed the services of S.B. Joseph and Co. to enforce the judgment before Babalola Chambers applied for variation of the judgment. This was presumed to be because the Badamasi Eleto family wanted to avoid paying Babalola Chamber its professional fees. Okay, the affected estate and individuals immediately filed fresh suit against the Eleto family with the purpose of frustrating the judgment of the Supreme Court. The Eleto family was lured by the affected estate to settle some of the suits behind Babalola Chamber despite being counsel on record. They filed terms of settlements with court without the knowledge of Babalola Chambers. So is this all the cause of the problem between Farotimi and Babalola? Because I don't understand. The Lagos State government issued a publication indicating their awareness of the Supreme Court judgment and the need for the state to intervene in order to maintain public peace and order. The Lagos State government invited the Eleto family, and a compromise was reached so as to avoid the massive dislocation of persons and communities directly affected by the judgment. Once Mr. Dele Farotimi can show proof that his assertions in the book are true, then he will be free. So all these statements now, I did not see where they wrote, so because of that is why you brought him all the way to Ekiti to judge him. And see, until then, the law allows free speech, but not one that is calculated to injure the good reputation of another. All facts are verifiable. I urge Nigerians to verify and find out the truth. Is first before picking a side. Okay, we have heard you. Shall release the man because I don't know why you're arresting him. There's freedom of speech, so Jaisimi said he can prove the allegations without you putting him in jail, Abi. He doesn't even need to prove anything. It doesn't need to prove anything. It is the same thing that he's accusing you of. That is the same thing that you are doing right now. Arresting him, allowing the judge to say that, oh, they should not release him and let him go. They should not give him bail. Because of what? Did he kill somebody? No, he did not. So obviously, you are giving us enough evidence already. My listeners, over to you. Leave your thoughts in the comment section. Don't forget to like, to share, and subscribe. Thank you for listening. See you some other time. Bye.